Welcome, everyone, to today's podcast. This is on behalf of the American Health Lawyers Association, AHLA, and its Physician Organizations Practice Group. Today is part of our series on the top 10 issues in health law for 2025. And today we'll be talking about gender-affirming care and the issues that have happened in past years and looking forward to the coming year, the things that we expect. And we're here with my guest today, Jenny Nelson Carney from Epstein Becker Green. Jenny, thanks for being here today.
Thanks so much, Adam. I'm really pleased to be able to participate in the podcast today. And I'd be remiss if I didn't mention too that I chair AHLA's Women's Leadership Council, which is a great organization. So for anyone listening to this that would like to get involved, please reach out on that. But I'm excited to speak with you, Adam, about gender affirming care. There's obviously a lot of activity happening.
Sure. And Jenny, did you want to say anything about your practice? Then maybe I can introduce before we get into the substance.
Sure, sure. Thank you for that. So, as you mentioned, I'm a partner at Epstein Becker and Green. I'm a healthcare regulatory attorney. I work a lot with providers and trying to help them provide good patient care from really intake to discharge and get paid for it and comply with all the regulations at the state and federal level that they are subject to. So I've been practicing for 21 years and really enjoy the area of healthcare law, and have been a member of AHLA the whole time, which has been really, really enjoyable.
And just for everyone, my name is Adam Laughton. I'm a shareholder at Greenberg Traurig in our Houston, Texas office. I'm also a healthcare attorney doing transactions and regulatory work. I also work with many healthcare providers, many of who are also involved in this area of sort of gender affirming care, what we think of as reproductive health, and advising and counseling them on various regulatory issues, especially these that are changing at the state and federal level, it seems like every day. So, Jenny, to start our conversation, I think so much of the conversation around this is, what jargon do we use in vocabulary and using the right words for things? So why don't you give us a good definition of gender affirming care for purposes of this discussion?
Sure, Adam, that's a great place to start. So, gender affirming care is really an umbrella term covering a range of different medical interventions used to support individuals where there's a conflict between the individual's gender identity and the gender that they were assigned at birth. That's the definition that we most typically see. So, I think one of the misunderstandings often is that gender affirming care is just surgical procedures, but it's really just a broad category, and it includes things like social affirmations, which may be things like changes to someone's appearance, even down to the clothes they wear, and use of pronouns. A second part of that would be medications like puberty blockers and hormone therapy, which we're hearing a lot about these days. Third would be surgical procedures. And then fourth is sort of the legal piece of it, where someone might change their gender and name on legal documents, and that's often referred to as legal affirmation. So within each of those categories, you'll see some of them, some forms of gender affirming care are easily reversible, like social affirmations, and others are not easily reversible, like surgical procedures. Most of the recent focus that we've seen on gender affirming care has been related to minors. And so I think it's important to think through what that means, because gender affirming care for minors is typically care that involves not just the minor, but their parent or guardian and medical professionals working together to make decisions about the care that the minor receives. I will say it is more unusual for permanent medical interventions to occur before a transgender person is old enough to give informed consent. So, what we usually see with minors who are receiving gender affirming care is prior to puberty, we see things like the social transition, like changing names, pronouns, and clothing. And then during or after puberty is when we might see the availability of certain types of medical treatment. It might just be medication at that point. I think, you see most of the surgical interventions happening with adults. But I think the other piece of this that's important to keep in mind is that in the United States, there's about 1.6 million people ages 13 and older who identify as transgender. So while that is a small number compared to the total population of the country, it's under 1%. It's a large enough number that many healthcare providers are caring for patients who are transgender.
Great, thank you. And so AHLA identified gender affirming care as one of its top 10 issues for 2025. And you wrote the article for AHLA, which appeared in its magazine in January of this year. And that identification is sort of in part based on things that may have happened in 2024, but also anticipating things that are going to happen in 2025. So just maybe to start this question, what are things that happened in 2024, and obviously some of them may bleed over into 2025, but what are some of the things that happened in 2024 that might have led to the AHLA identifying this as a top issue?
Yeah, it's an important point and a good question. So although gender affirming care has taken a really prominent position in the beginning of 2025, we're seeing it in the news daily. It was an important issue, an important health law issue in 2024 and really a few years before that as well. And when I say that, obviously, it's always been an important issue to people providing the care and people receiving the care, but it's become more of a prominent issue to the general public in the last few years. And really, it seems like the reason for that is because we've had a growing number of states that have moved to either restrict or protect access to certain treatments for gender diverse people via state legislation. And most of those laws, almost all of them, are focused on minors. As of the recording of this podcast, I believe we have 27 states that have enacted legislation to restrict certain forms of gender affirming care for minors. Most of those, 25 of them, I believe, ban surgery and medication, and the remaining two only ban surgery but allow some forms of medication. In addition, 24 of those states impose professional or legal penalties on healthcare practitioners who provide minors with gender affirming care. So again, what I'm describing there is the states that have taken a restrictive position on this type of care. On the other side, the remaining 23 states plus District of Columbia and 5 territories either have no legislative restrictions on the provision or access to gender affirming care or actively protect access to it. So clearly a ton of state activity along this line that have really brought this issue to the public's attention. We've also seen activity from some state medical boards to hold individual providers accountable for violations of the laws restricting provision of gender affirming care. So in particular, Texas law directs that the Texas Medical Board, which oversees provision of medical services in Texas, the law directs that the medical board there revokes the medical license or other authorization to practice medicine of a physician who violates those provisions of Texas state law that prohibit gender transition medical interventions such as surgeries, puberty blockers, and provision of hormones for minors, many of those things that we just discussed. Another example of a state that does that is Georgia, which holds physicians administratively accountable for violations of some of the restrictive gender affirming care laws. So we are expecting to see increased activity from the medical boards in states that have taken a restrictive position on the provision of gender affirming care. Those states have sort of been out front on it, but we expect to see more of that activity in the restrictive states going forward.
So one thing that, just people, not even lawyers following this in the news, may have heard with regards to, whether you call it transgender care, gender affirming care, that there are cases working their way through the courts at various levels. And there's one case, or at least one case, before the Supreme Court this past term, I believe it's called Skrmetti. Could you give us a brief overview of what that case is about, where it stands, and what's happening there, what we expect?
Sure. Yeah, it's a very important case for this area of medicine. So, the Skrmetti case was brought by families of transgender minors, and it revolves around the question of whether a Tennessee law, which prohibits all medical treatments intended to allow a minor to identify with or live as a purported identity inconsistent with the minor's sex. So, that's a quote from the law, or to treat, and again, another quote, purported discomfort or distress from a discordance between the minor's sex and asserted identity. So the question is whether that law violates the Equal Protection Clause of the 14th Amendment of the US Constitution. Uh, so this case has been going on for quite a while, as we know, cases go on typically for a while before they reach the Supreme Court of the United States. And under the past administration, the Biden administration actually intervened in this case to challenge the state's law, meaning the Biden administration agreed with the families that brought the case. After the U.S. Court of Appeals for the Sixth Circuit upheld the Tennessee ban, meaning they said to the state, yes, we agree that you can ban this care, both the Biden administration and the families asked for the Supreme Court of the United States to take the case. So one of the key issues here for the case is that the Supreme Court justices must determine what standard of review the court should use. The court typically treats classifications like race, religion, national origin as suspect, meaning that they're subject to a higher level of scrutiny. So if the court decides that the classification that Tennessee is making is based upon a suspect classification, the court will scrutinize the law more closely. However, if the court decides that the classification is not suspect, the court will give Tennessee more deference with this state law. So the plaintiffs in this case are arguing that the law should be treated with more skepticism because they say it facially discriminates on sex, whereas Tennessee is arguing that it is not a sex classification at all, that instead the law is restrictive relative to age, minors versus adults, and purpose, no transitioning for anyone. So those are the positions of the two sides. And the Supreme Court heard oral arguments in the case early December, December 4th. And at that point, we thought, okay, now we're just going to wait and get a decision later in the term. But we did have some additional activity once the Trump administration took over. Then in early February, the Trump administration notified the Supreme Court that in its view, the Tennessee law does not violate the Constitution, meaning the Trump administration changed the government's position on this pending case since the Biden administration had taken the opposing position. So, but the Trump administration did encourage the court to decide the case, so to go forth. So we expect to see a decision in June, probably. This will be a late decision in June of this year. And if the Supreme Court agrees with Tennessee, we will likely see more state laws restricting provision of and access to gender-affirming care. If the court instead sides with the practitioners, we could either see the Tennessee law struck down, or we could see the case returned to the lower courts for reconsideration. Either way, we expect this to be a very important decision relative to provision of and access to gender-affirming care in the United States.
And that's actually a great segue. You bring up sort of the new presidential administration, and obviously, even as it relates to this one issue, gender affirming care, for those of us who follow this professionally, the day-to-day changes are dramatic and numerous, and we're sort of barely able to keep up with everything and all the different directions they're pointing. So talk to us about some of the major changes and initiatives and projects that are coming out of the Trump administration with relation to gender affirming care.
Certainly. And Adam, you're correct. This has been almost daily activity since Trump was sworn into office. So I'll do a linear overview of what's happening, understanding that there's so much that's still pending at the point of recording this podcast. And so we should expect to see a lot of activity in the next few months. But on January 20th, the White House issued an executive order that was titled Defending Women from Gender Ideology, Extremism, and Restoring Biological Truth to the Federal Government. So this is an executive order that stated that it is the policy of the United States to recognize only two sexes, male and female, and it specifically said that the sexes are not changeable. In addition, the executive order directed federal agencies to enforce laws protecting men and women as biologically distinct sexes and to use the term sex and not gender. And the EO also prohibited the federal government from expending federal funds to promote gender ideology with the idea that gender identity could differ from biological sex. So that was sort of, we heard a lot of this from President Trump when he was campaigning, that this was an issue that was important to him. But this executive order was sort of the first official indication that he was planning to take action on this topic. It was quickly followed within the next week. The second order came out January 28th, I believe, where he issued another executive order, this one more directed to healthcare providers in particular. So this one was called Protecting Children from Chemical and Surgical Mutilation, which is the Trump administration's description of gender transition care. So this executive order directed the federal agencies to take appropriate steps, which they called appropriate steps, so not necessarily delineated, but to take appropriate steps to ensure that institutions receiving federal research or education grants, which would be institutions like medical schools and hospitals and health systems. So any of those entities receiving those federal research or education grants need to end the chemical and surgical mutilation of children. So again, Trump is directing the agencies to take steps to have anyone receiving these funds end that type of care. What was really interesting about this is they defined in the executive order children to be individuals under 19 years of age, which, in most states, the age of majority is 18, and that's what we typically see. 18 and under are considered a minor, but this defined children as under 19. So there's a 1 year classification of what we would typically think of an adult that would be captured under this order. The order also terminated coverage for certain gender-affirming care, government-provided medical benefits, and ordered Health and Human Services, HHS, to withdraw its March 2022 guidance on gender-affirming care, civil rights, and patient privacy. So that was guidance that came out under the Biden administration, providing protections for gender-affirming care and the individuals receiving it. And the executive order, it indicated that HHS should issue new guidance protecting whistleblowers who take action related to ensuring compliance with this EO. So pretty serious and significant there. Finally, the order directed the Department of Justice to prioritize enforcement of an existing federal law prohibiting female genital mutilation. That law was enacted years ago for other purposes, but it is clear that the administration wants to use it for this purpose to address gender-affirming care. So this order has garnered a lot of attention from healthcare providers who are currently providing some form of gender-affirming care. And though the order is mostly forward-looking, almost everything is directing the agencies to do something. There's that one piece about an existing federal law that I just mentioned, but the rest of it is largely forward-looking. We still have seen healthcare providers make some immediate changes to the services that they're providing. And as a result, we've also seen some significant litigation arise. So on February 4th, so not very long after these two executive orders came out, PFLAG, which is a national LGBT advocacy organization, and other plaintiffs who are largely impacted individuals receiving gender-affirming care and their families, filed suit in the District Court of Maryland, arguing that these executive orders are unconstitutional presidential action, meaning that they are in excess of the president's authority under Article 2 of the Constitution, and also that they infringe upon powers reserved for Congress. They also said that the EOs discriminate on the basis of sex and disability in violation of U.S. laws, that the EOs violate the Fifth Amendment's equal protection and substantive due process guarantees, and that the EOs violate the First Amendment's free speech clause. So pretty meaty claims. The plaintiffs in this case want the court to declare the EOs unconstitutional and unlawful, and they've asked for temporary, preliminary, and permanent injunctive relief to keep the agencies from implementing or enforcing the EOs or otherwise withholding federal funding based upon the fact that a healthcare entity provides gender-affirming care. So as of the recording of this podcast, the court there has granted a preliminary injunction, and we expect to see more activity from that case over the next few weeks. And so, as I mentioned, that case is in Maryland. We've got another important case on the other coast. This one's on the West Coast, arising out of Washington. So this one was filed February 7th, and 3 states and 3 physicians filed suit in the Western District of Washington, which is in Seattle, arguing that the mutilation executive order, so that second executive order that we discussed, they say it violates Fifth Amendment equal protection by creating classifications based on transgender sex status and sex, and facially discriminating on the basis of transgender status and sex without sufficient government interest, meaning there's no reason for the government to be doing this, these things that they're doing. They say there's not sufficient government interest. So the plaintiffs also allege that the order violates, again, separation of powers by imposing conditions on the receipt of federal funding by medical institutions, despite the fact that Congress never authorized such a provision. So again, alleging overreach, and noting that Congress explicitly barred medical institutions from denying individuals access to federally funded services based on gender dysphoria under a federal law relative to non-discrimination under federal grants and programs. Finally, the plaintiffs allege that the order violates the 10th Amendment of the Constitution by regulating the practice of medicine without congressional authorization. So this case is also under preliminary injunction against the enforcement of the majority of the executive orders. So 2 really significant cases that everyone who's tuned in this issue should watch, and because the outcomes there will be significant for anyone receiving or providing gender-affirming care. But we've also, in the meantime, started to see some activity at the agencies. So again, recall that the executive orders are the Trump administration directing the agencies to take action. So on March 5th, CMS, which is the Centers for Medicare and Medicaid Services, issued a memo to healthcare providers that CMS may is the term they use, may begin taking steps in the future to align policy, including CMS regulated provider requirements and agreements, with the highest quality medical evidence in the treatment of the nation's children in order to protect them from harmful, often irreversible mutilation, including sterilization practices. So directly lifting some language from the EO. But again, it's this memo from CMS said CMS may begin taking steps, and it also says the memo that CMS will follow any applicable substantive and procedural requirements in order to take any future action. So the issuance of the memo drew a lot of attention, but the memo itself doesn't specifically say, hey, this is what we're doing right now, this is what's happening. It's saying we may take these steps in the future. And if we do so, we will do it the right way, is what the summary of the memo. And then we saw several other memos come out right after that. So the next day, HRSA, which is Health Resources and Services Administration, issued a letter addressed to hospital administrators, colleagues, and grant recipients, indicating that it would review its own policies, grants, and programs in light of the concerns that CMS discussed in its memo. And again, use the language, we may begin taking steps in the future to appropriately update policies to protect children from chemical and surgical mutilation. So again, still forward-looking. And HRSA also included that same statement about that it will follow any applicable substantive and procedural requirements in taking future action. Similarly, we got a memo from SAMHSA, which is the Substance Abuse and Mental Health Services Administration. This letter was addressed to colleagues and grantees, indicated that it too would begin reviewing its policies, grants, and programs in light of the concerns discussed by CMS. And it also, SAMHSA noted that it may consider rescoping, delaying, or potentially canceling new grants in the future, depending on the nature of the work and any future policy changes that SAMHSA may make. So that certainly got a lot of attention. But again, 3 memos from 3 government agencies saying this is what we may begin doing in the future. So I guess the summary here is we're seeing daily activity both in the cases that I mentioned and in communications from the agencies, and expect that to keep up.
And that may language that showed up in each of those memos is very interesting because, on the one hand, providers, our clients can argue, well, that doesn't exactly provide clear guidance as to what we should or should not be doing until as you may take steps, but also they may in some cases, they may and not, and it becomes a question of the agency's enforcement discretion as well. When do they start? Did they start yesterday? Did they start today? Do they do it with one hospital? Do they not do it with another one? And how do they make these decisions? So it's a very complex area. So that may bring us around to my final question, which is we're talking to clients, again, healthcare providers every day. How do you counsel them when dealing with, this flurry of activity, but also just the basic uncertainty of, well, we know these things have happened. There are these other things out here we don't know will happen, if they will happen, when they will happen. How do you counsel them about those things?
Well, Adam, that's the $40 million question, and not to be self-promotional for healthcare lawyers, but it's going to sound that way. What we're saying is make sure you're working with your legal team, whether that's your in-house counsel or your outside counsel. The pending litigation is significant, both the Supreme Court's case and the Washington case and the Maryland case. And we certainly expect to see continued activity from the federal agencies, even though those memos say may. It's certainly an indication of where they expect to go. And the Trump administration has been clear about where they're intending to go. So the key is to work hand in hand with your legal team to stay up to date, make sure you know the latest, and understand what services you may be providing, and where those services fall along the risk continuum. I know because you work in this area that this as well as I do, that these providers are just trying to provide good care to all of their patient population. At the end of the day, they want to make sure that they're providing good, appropriate care to their patients. And so this is a tricky situation because everything's changing so rapidly. So the best we can do at this point is to say, pay attention, know what you're doing, and work hand in hand with your legal team to determine the best next steps.
Jenny, thank you so much for being with us today. Just in wrapping up, this is such an interesting area because of the constant developments, and it's so important because, as you said, while that 1.6 million that you mentioned seems like a small number when you look at the entire American population, that's still a lot of people, and it's all over the country, not just all concentrated in one state, but they're spread out in probably every community in the nation. And so thank you so much for writing the article and then being available to be a part of this podcast. Just thank you for everyone listening. This has been the American Health Lawyers Association podcast on the top 10 issues in healthcare for 2025. And today we are focusing on gender affirming care. So thank you, everyone, and goodbye.